We return for another conversation here on Chicago's Legal Latte. Hi, everyone. This is Jim Mitchell, and we're going to dig into a specific litigation issue today, and we'll do that with the help of Lavelle Law shareholder Matthew Sheahin. Matt has joined us many times on podcasts in the past. And Matt, first of all, thanks for taking the time. This is going to be a good conversation, so your help is going to be very beneficial. So great to talk to you again.
Happy to join.
In the past, we've talked about things like trademarks and copyrights and things that businesses need to worry about. We're going to talk about infringement today, but let's go back and redefine what we mean specifically when we use the term trademark.
So a trademark is a word or a design that indicates the source of goods or services. Some of the more famous trademarks, I guess everyone knows, are things like Nike, Chiquita, any of those words, and you can, the swoosh and the woman with the fruit on her head. People know those names and those logos and what they refer to. So those are registered trademarks in both cases by obviously multi-billion-dollar global companies, but there's also a lot of different size companies that can register for trademarks and do, and it's always rife with disputes because frequently you have other competing businesses that are in the same line of goods and services using either part of your name or a similar type of mark, and that's where we get into a battle over trademark infringement.
And you mentioned registering a trademark. There's a process that a company would go through to set up that type of protection?
Yes. So, and our transactional team here at Lavelle would do that. Ted and Steve and their team registers trademarks regularly, every year. It usually starts with client will come with a logo design or a name that they want to see if they can register as a federal trademark. We'll do a search of that name or logo and see if we think that it might be available. We can't make that determination, of course. But we can look to see if there's already a trademark with the exact same name that's registered. We'll tell the client it's not available. If the name's a little bit different or substantially different, but might use a word or two of the same name, but we still think it's different enough, especially if it's in a different line of goods or services where they won't be confused. We may go ahead and file, with the client's permission, file for a trademark application with the United States Patent and Trademark Office, and then their examination office will go through it, and that's who actually approves the trademark and then gives you a registered trademark, which is, if you have that, that's what lawyers would call prima facie evidence of a trademark. You can use that registration in litigation to demonstrate that you have in most cases, have a superior right over anyone else over that particular trademark or design.
So today, when we talk about infringement of a trademark, what does that typically incur? What are the most typical ways that trademark would be stuck?
Sure. Well, typically, most people want to avoid litigation if at all possible. So, for example, one recent example we've had was in regards to a restaurant using, and they do have a federal trademark, and it can't be just like a generic name, right? It can't just be eggs or milk, those generic terms. But if it's something more descriptive, like there's for example, a restaurant in Wheaton called Eglectic. I'm not sure if they've registered that actually as a trademark, but we had another restaurant that registered a trademark, and we discovered a restaurant in Northwest, and they've got 3 or 4 locations. They've got a federal registration, and there was a restaurant in Northwest Indiana using the main part of its name as its name. So we tried to avoid litigation and sent a cease and desist letter, demonstrating to that particular restaurant that our client had the federal registered trademark, and telling them that they need to change their name. Which, you can imagine for a restaurant that entails a lot of work. They got to change the menu, they got to change the website, they got to change literally the physical sign on top
signage. Yeah.
signage on the store. So different parties go about different ways. You can tell them you better do it or I'm going to sue you and not offer anything. Other parties might say, you can do it, but I'm going to give you a reasonable time, to make those changes. And some parties will even say, just to try and protect their trademark, they might even offer money to the infringer. And we know it's going to cost you about X amount of dollars. We're willing to pay some of that, half of that, something like that, to try and encourage them to do it without having to litigate. But of course, sometimes you get a response that's not what you want to hear, and they're not going to change anything. And then a decision comes as to whether or not you want to file suit.
And are you able to frequently resolve these things through a letter, a phone call, a negotiation, or do they often turn into a more full-blown legal action?
Yeah, I mean, every case is different. We usually do try to work it out, and in most cases, whether I'm representing an owner of a trademark or someone who received a cease and desist letter, we do try to work through those issues, and certainly the lawyers will kind of volley back and forth about different, because there are certain defenses you could possibly have. You might not think it would cause confusion in the marketplace, and I can give you an example of that. But it really depends on how reasonable the other party is, or how reasonable, even if the alleged infringer, if they really don't think it's causing confusion in the marketplace and doesn't qualify as infringement, they might stand their ground, and they might have a reasonable basis to do so. Reasonable minds can disagree, and that's usually when you end up.
And in terms of examples, you mentioned just a small restaurant or a small chain. If there's one here in the Chicago area and there's another one out in Montana, you go, hey, we're never going to cross paths. Is that the kind of thing where perhaps you might stand down, or is it, hey, this is our mark, we got to protect it?
Yeah, it depends on that. It might not be worthwhile. The other example I gave you where it's we've got 3 restaurants in Illinois, and this is in Northwest Indiana. That's stuff where you could get some confusion there, especially if the trademark owner feels like their business and service is a higher quality, and they don't want the confusion to be demonstrating something they think is not quite as good as their service. But yeah, if you have a similar named restaurant up in the corner of Washington, and you own the same type of restaurant in Florida, you might not think it's worth it, and it very well may not be, especially if you have a single location. There's actually a pretty famous example of Burger King in Mattoon, Illinois. There was a restaurant called Burger King in Mattoon, Illinois, and it predated the national chain obtaining their registered trademark. And when Burger King asked them to stop, they said, no, we were here before you, even though we don't have a trademark. They actually had, and they litigated this. And the Mattoon restaurant actually won, and because they had what we call common law rights. They had been there first. They had been using that name conspicuously, but for everyone to see for a number of years before the national chain registered its trademark. So actually, the court found that the original Mattoon Burger King can stand, and the Burger King franchise can't put anything in there within about, I think it's a 20-mile radius or something like that.
Oh, wow.
So that has happened in the past. So good for those business owners that protected their rights, and Burger King is the national chain is certainly respected that.
We're talking with Matthew Sheahin today, shareholder at Lavelle Law, talking about trademark infringement. Time always flies by in these conversations. But Matt, let's get into the specifics a little bit here. What you mentioned, I think the U.S. Patent Office, is that what the law or code is that covers trademarks? Does it come out of there?
The trademark office will make the examination, and they've got a lot of rules and regulations. But if you're going to suit, you're generally going to end up in federal court under what's called the Lanham Act. That covers the federal statute. So the federal courts have jurisdiction, of course, to enforce federal statutes, and that's where most of the trademark infringement claims lie. So typically, and a lot of times you have also diversity jurisdiction, because you might have an Illinois plaintiff against a Florida defendant. So you've got that as well. But with the Lanham Act, you're going to have federal jurisdiction regardless. And, you can bring a lot of different claims. Typically, just looking at some of the things we brought, there might be just straight trademark infringement under under the Act. There can be other claims for unfair competition, trademark dilution, which means by using the mark, you're kind of diluting my federal registered trademark, weakening its effectiveness in the marketplace. Certainly, there could, a lot of trademarks might have a copyright as well. Depends on what you're selling. But those are the typical type of claims that you see. And then there might be some supplemental state claims that people can bring in federal court as well. And one of the examples we have, and this is, I can show you this because it's public record and court filing in federal court in the Northern District of Illinois. We represented this comic book maker that made these kind of cool books of classic stories, but under a comic book kind of format.
Okay.
So Rob Roy, they've got War of the Worlds, they've got all these, and they have this distinctive mark of classic illustrated, featuring the world's greatest authors. They've got this open page book, and in this case, we sued what we felt like was a comic book maker that was infringing on the mark. He was not, or the company was not actually using the name Classics Illustrated. He had changed it to Jack Lake Classics, but he was using, the same type of type here, type, and he also had this tagline and the open book.
Oh, wow.
And it was very similar, the cover.
Yeah.
So it was still, even though it wasn't exactly like, it was similar enough that it was causing confusion in the marketplace under our theory. And they did plead like I would plead. I represented in another case in Northern District. In fact, I mentioned it before, Chiquita. Our client had a couple of supermarkets called Chiquita Food Market, and they, we had various defenses in that case. We settled the case with Chiquita, and I can't get into the confidential terms, but in that case, for our client, we didn't feel we were infringing because it wasn't, everyone knows it's not a global produce company. It's a local Hispanic grocery store, and Chiquita is a Spanish word for little girl. I mean, there's so many products, if you look around the world, that have the word Chiquita in it. And so we were arguing that it wasn't causing any confusion in the marketplace. They were distinguishable marks that, they don't own the exclusive rights to the term Chiquita. There was no direct competition. There was no damages to them, all those type of things. Ultimately, we resolved, out of all the cases that are filed in the United States, whether it's for trademark or anything else, the great majority don't go all the way to trial. It's an expensive, time-consuming, stressful process. And most people, unless they have the wherewithal monetarily and the strength of their case, they might not want to go all that way. So there's a lot of cases that do resolve by way of settlement. And that's the idea with the cease and desist. It's to try to do it before you get in litigation. But even once you're in litigation, many times the parties are able to broker a deal that everyone finds, tolerable enough to resolve the case.
So, and a couple minutes left here, but I really want to follow up here. You mentioned the process. Do you simply need to show that there are similarities, that visually you can look at it and say, yep, those look like one is taken from the other? Or do you need to prove in some way that there's been some damage or harm by happening?
You generally need to do both. And, I could, in the Chiquita case, you can see their point that it's still in the food industry. And those are just fact issues that we never got to that would be tried. And, the jury or the judge would make those determinations. In that particular case, the parties were able to work something out.
And recent headlines, in fact, recent as in, an hour or so before we started talking here, we got an update on a case with Nike, which is probably one of the top 5 global brands. And it looks like they just won some relief in a case that they were involved with. Yeah,
and this is really at the trademark office level. So it's not involving, I understand it's not involving like disputed litigation with someone else claiming the rights to it over Nike, but they had, Nike had tried to register a trademark called capital S, capital N, capital K, capital R, capital S. So kind of a quick shortened term for sneakers. They've been selling, online under that name since about 2015, and it's Nike, so they've made millions of sales. But the first go around, the USPTO found that term was too generic. It's just a shortened version of the word sneaker, which everyone knows is just a different name for basically a gym shoe. But ultimately, Nike was able to convince the Trademark Trial and Appeal Board that that particular use, the way that they display it, the capital letters in that order, was enough to not be generic, and that they did grant the trademark to Nike. So now Nike has that ability to use that term in its online sales and whatever marketing it's going to use it for. So they'll have that exclusive use, and I'm sure if anyone tries to go online and sell shoes under that name without their permission or license, they will most likely get sued by Nike.
It's an interesting position to be in. So two things.
And that decision, Jim, you're right. I think it came down literally yesterday.
Okay. Yeah. And that's, those are the ones that are interesting to look at and try and see how they're going to evolve now. And before we let you go, two things. One, I want you to tell us how people get a hold of you if they have a concern, if there's something that they feel is worthy for you to take a look at. And as you do that, is it also imperative, we didn't really mention that, if a company is starting out or launching a new product, the importance of getting this done right away, right up front. So first of all, tell us where we can reach you, and then give me a quick view on what businesses should be.
Sure. You can reach me at msheahin@lavellelaw.com. You can go on our website. There's our contact information is all there, lavellelaw.com. You can find any of the attorneys here, frankly. Or my direct dial is 312-332-2855. Our general number is 847-705-7555. And for any business that thinks it has a trademark worth registering, it's certainly worthwhile to have a discussion with one of our transactional attorneys to look into it. It's not very costly to at least allow us to do a search and even in that initial discussion, we're going to be able to tell you whether or not we think it might be, even have the ability to be trademarked. After a discussion, you might realize it's not worthy of a trademark. But if we do think it is, then we'll do the search and tell you if there's, if it's worthwhile to go through the process. Of course, we're not the USPTO, as Nike found out. And we have to go through that process and ultimately live with their decision or appeal it and overturn it like Nike did. But it's probably in a 10-minute conversation, we can probably let you know if it's something that's worth pursuing.
Matt, thanks very much for the time today. Always great to talk to you, and hopefully we'll get a chance to follow up at some point, but always appreciate the insights. So have a great day.
All right. Thank you.
Thanks, Matt.